Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. We have been reporting on the Idaho for defamation case, which we've been referring to as such because it directly relates to the crimes that occurred at 1122 King Road and involves a federal lawsuit brought by a professor of the University of Idaho against an online personality / psychic. The plaintiff, Rebecca Schofield, initiated this lawsuit back on December 21st, 2022, against the defendant, Ashley Guillard. The plaintiff filed a motion in limine back in October, and the court has now rendered a ruling in plaintiff's favor. The court order reads as follows. Plaintiff's motion in limine seeks an order prohibiting defendant from presenting evidence or argument concerning the purported, and then in parentheses, truth, and in parentheses, of defendant's prior statements, alleging that plaintiff had an affair with a student and orchestrated the unalivings of 4 University of Idaho students. Plaintiff contends that because the court has already determined liability, such evidence is irrelevant to the sole remaining issue for trial damages and would risk confusing and prejudicing the jury. The court has already determined as a matter of law that the defendant's statements accusing plaintiff of an affair and involvement in the unalivings were false and defamatory. And the court refers to the partial summary judgment motion and order granting plaintiff this relief dated June 6, 2024. Liability is no longer in dispute, the court reasons. The upcoming trial is limited to determining the amount of damages to which plaintiff is entitled. Thus, any evidence or argument offered to suggest that defendant's statements were true or that there was some factual basis for them has no bearing on any issue the jury must decide. Such evidence is therefore not relevant, and then citing 2 Federal Rules of Evidence 401 and 402 for that proposition. Court goes on, even assuming that such evidence could be framed as marginally relevant, it would nonetheless be excluded under Federal Rule of Evidence 403, allowing defendant to advance well after the fact arguments or evidence concerning the quote-unquote truth of the defamatory statements would present a substantial risk of confusing the issues and misleading the jury as to the scope of the trial. The danger of unfair prejudice is particularly present given the inflammatory nature of the allegations and the likelihood that such evidence would distract from the proper focus of the damages inquiry. Any minimal probative value is substantially outweighed by these risks, as well as by the prospects of undue delay and a waste of time. Then the court points out that the defendant has not formally opposed the plaintiff's motion in limine, and therefore, under Local Rule 7.1F1, failure to file a response may be deemed to constitute a consent to the granting of the motion. Accordingly, in the exercise of its discretion, and mindful that its ruling remains subject to revisions should circumstances at trial warrant, plaintiff's arguments are ultimately persuasive. Unless otherwise permitted, defendant shall not present evidence or argument at trial concerning the purported truth of the defamatory statements involved in this case. Plaintiff's motion in limine is therefore granted. As we had previously noted in our coverage of Schofield versus Guillard, ladies and gentlemen, the plaintiff, who is proceeding pro se, was very active in the case until September of 2025, when she stopped filing documents. She missed a number of deadlines for pretrial matters, including the submission of witness lists, the submission of proposed questions for jurors and juror selection. She missed a deadline to submit her trial brief and a number of other crucial deadlines. The judge had also pointed out that she did not respond to the in limine motion which the plaintiff filed back in October, and it was seen as, under the local rules, unopposed. And so therefore the ruling has been made. Trial is scheduled to commence in federal court in Boise on the 24th of February, 2026. We will continue to keep you posted as further developments arise. Until next time, this is Kathy. Thank you for joining us here today.